Great. It's 6 o'clock, and I think we're good to begin. Uh, Welcome to the last and final episode of our Conscience Keeper series that is being brought to you by Vidhi Centre for Legal Policy in collaboration with the Kautilya Society at the National Law University, Orissa. Over the course of the last month, we've had a series of events on looking at the role of the courts and the Constitution, ranging from Justice Sri Krishna and Salman Khurshid talking about the pressures of being a judge, to Aparna Chandra talking on the master of the roster, and a range of issues in between. We have saved one of the most topical issues for the end, which is the question of free speech in our constitutional framework and its restrictions. And I'm delighted to be joined by two friends, Prashant Iyengar and HR Venkatesh. It's a real delight to be part of this conversation. Thank you very much, Prashant and Venkatesh, for being with me today from a chilly New Delhi, as you can see, and perhaps a chillier New York, but a warmer room inside. So Prashant is currently doing his doctoral work at the Columbia University. He's a legal academic, has worked extensively on technology-related laws and intellectual property, amongst a range of other subjects. And personally, for me, as in he started what I think was India's first open source platform database for legal judgments, which was called Open Judice, and it still exists. And was a leader of sorts in making sure judgments are openly available. Thank you very much, Prashant, for joining me today in this conversation. H.R. Venkatesh is a renowned journalist. You would have seen him in his earlier avatar on TV. Now he runs a very provocative and a series called Media Buddhi, and is the director training at Boom Fact Check. He's been a visiting fellow at Stanford University and has a range of academic degrees as well as professional achievements to his credit. Thanks very much, Venkatesh, for joining us. And this is the kind of conversation that we like to have between lawyers and journalists, social scientists, civil society, so as to make sure that the law doesn't remain in its ivory tower. Thank you very much, Prashant and Venkatesh, for joining us. For all the attendees who are joining us today on Zoom as well as on Facebook, please feel free to ask your questions in the chat box. We'll try and take as many questions as possible. The format of the event is the discussion is that we just have a little chat going between the three of us. And if you have questions, please feel free to write in the chat box and I'll take it forward. Uh, we're having this conversation at an interesting time because it feels as if free speech in India is restricted like no other time before. But perhaps that's not the case, or perhaps it is. We don't know because we live in an age where everything seems exceptional. But there is one thing that can certainly be said, which is that the Supreme Court finds itself as at the center of a lot of discussions around free speech. Just very recently, if we look at judgments from the last month or two, the Supreme Court upheld free speech in letting Arnab Goswami go on bail. It restricted speech in preventing the broadcast of the show Bindas Bowl on Sudarshan News, and also upheld it while staying a shocking judgment from the Andhra Pradesh High Court in banning all media reporting of a particular case. So the record, like any other institution, is perhaps mixed. Uh, so I wanted to start with Venkatesh to get a perspective on how, as a journalist, he sees the Supreme Court. Do you see the court differently when you're reporting on the court, when you're talking about the court, or do you see it as a bulwark against all kinds of incursions into free speech?
I mean, for the last part, for the most part, rather, I, as a journalist, and I know many other colleagues of mine feel the same way, we don't think about the Supreme Court. We don't think too much about censorship because we tend to sort of take refuge in our institutions, and especially when you're working for a newspaper or a television channel, you have many, many more people that you can rely on, and you don't really worry too much about contempt, or you don't worry about what else, what other legal instrument can be used against you. But in the last few years, having been working in the digital space and noticing very clearly how journalism in the digital space is a little different, is a little freer when compared to print and TV, I've been taking note about various challenges to the freedom of the press. And of course, the behavior of the courts, and not just the upper judiciary, but the lower judiciary as well, and the entire legal system, the behavior of the police, the behavior of, whether you're easily able to get lawyers to look at your case and so on and so forth. That is something we keep a lot of, we, we give our attention to, especially this tactic of, one day you do a story and then you find that someone is put a case against you. If you're based in Ahmedabad, there's a case against you in Guwahati, or if you're in the eastern part of India, there's a case of you in the southern part of India, and then you've got to go and answer summons by yourself. So as people who work in this space, I don't worry about it at all, but very, very wary about where we will get into trouble with the lower courts. We still see the Supreme Court as a kind of bulwark, and we believe that we will get justice when we come to the Supreme Court. But at the lower courts, we're much, much more worried. I don't know if that answers your question.
But now that you're seeing courts more critically, because you said that given the fact that now you're in a digital medium, as opposed to your previous avatar on television, you're looking at courts more critically. But given the fact that you're looking at it more critically, as in, how do the courts hold up? As in, do you think that they are more restrictive than you imagined them to be earlier when you weren't looking at them, or especially with the lower courts?
I would say that it's difficult to look at just the behavior of the courts in isolation, because we look at it at how it affects our work. And we feel that the entire atmosphere for press freedom has it's become a little more restrictive. And so whether it is the judiciary, or whether it is the police force, or whether it is political parties, or whether it is commercial considerations or structural considerations, or these are all on every level. It seems like the ability to say whatever you want to say with responsibility, no doubt, but fearlessly, we're feeling hemmed in. So I just mentioned that it's a little different for print and television. I always knew that as a print journalist, there are many ways that a newspaper can control what I am going to say or not. As a TV channel, license can be taken away to broadcast, or I might not get a license to start a new channel. But so far in the digital space, there was no such restriction. But recently, the government has considered a few moves to make sure that, in an incremental basis, I see that the space to freely report without any fear has, is impinging on the digital space as well. So what that happens is, not just in an isolationist perspective or just looking at the courts, overall, the atmosphere for or against freedom of the press has changed, and we feel much more challenged now.
That's right. So let's take that to Prashant. As in, given the fact that what Venkatesh was saying was about the digital space and the relative freedom that is enjoyed in the digital space. But a recent example from the digital space and the exercise of the freedom of speech was, of course, in Prashant Bhushan's case, where Prashant Bhushan is tweeting about the Chief Justice of India, and which invites contempt of court, whether rightly or wrongly. Now, you have written a very incisive article there saying that that case is really not about the law, but it's about power, it's about politics. Uh, could you care to elaborate on that a little bit and think about how the digital space interacts with free speech or uses free speech generally, and how the courts look at it?
Right. Firstly, let me start by thanking you for inviting me here. This is a great series of talks, and I think a very important sort of juncture to stage these conversations. Responding particularly to that particular point, there's two things, right? There in what you asked me. Firstly, what do we make about digital speech, and the law? And second, was to do with, my article and politics. Let me dispense with the second one first. I think that article was sort of badly titled. It was not a title that I picked. But the point essentially that I was making over there was that we need to sort of reconceive the judiciary, and specifically the Supreme Court itself, as a political institution. And this ties in some senses to what you had earlier said. You said that the court has a patchy record, but let's build off that and go to the point that, look, the Supreme Court sort of has the self-image of itself as being completely neutral and being completely above every other institution. Now, this sort of self-perception that it has of being above politics is, I think, both untrue, and also it sort of leads to this a kind of extremely reactionary um, sort of attitude that it takes towards any suggestion that it may be politically implicated. And the thrust of my argument in that piece was to say that we need to sort of free up the Supreme Court, the Supreme Court's own ideology, to think of itself and reconceive itself as a political actor, because we all know that it is, and that's not a statement that's true only of the Indian judiciary or the Indian Supreme Court, but of courts and of judiciaries the world over. Now, that's not to say that the courts anywhere, and specifically the Indian judiciary, should have an easy relationship with politicians and politics in general. But it's simply to acknowledge the fact that the judiciary can't get all worked up when someone like Prashant Bhushan makes an allegation saying that the judiciary is sort of close to a particular political party or the ruling party in dispensation. I think we need to sort of move beyond the point where statements like that can scandalize. Getting to the other point about digital media, I think that I don't know if the question was, how do we think of law and of speech in the digital media in relation to the law. But essentially, let me try to answer it in this way. I think that what's happening is, and this is something that I'm going to say that should be fairly anodyne. I think our utterances on the internet have two elements to it. On the one hand, they smack of private conversation, which until the advent of the digital age, I was free to sit and have an adda with you, where I would berate everybody from the local politician to the Supreme Court, and none of this would be made would be scrutinized so heavily. So your tweets have and your Facebook posts have still retain that element of a intimate conversation. But there's also a public-facing aspect to it, where whatever you tweet immediately goes out to how many ever 1,000 or 1,000,000 followers that you are. Now, in that, so the thing is that our communications itself have now acquired this dual character. They are no longer easily categorizable into the private and the public. The private domain where conceivably they could not cause as much damage, and the public domain where they are open to criticism and punishment. So now the thing is that the Supreme Court of India, I don't think not just the Supreme Court of India, but I think all judiciaries of the world over are grappling with this dual nature of our communications. Because on the one hand, you cannot simply, apply the old regime and say that, look, this is strictly a private conversation, so we can't hold you liable. On the other hand, this isn't publication of the old kind either. Okay, this is still private people having a conversation in a persistent medium. So the thing is that I don't think that necessarily the Indian solution has been the good one or any other solution. I think the world over regimes are working through this particular question.
That's right. So I think we have two clear strands of discussion here. One is about how we grapple with the changing nature of speech now that the internet has come about, and do we think of Facebook as the town square, or do we think about it as the living room? I think there's one set of questions around that. I'm going to park that for 1 minute. And then there is another set of institutional questions about the Supreme Court. So let's try and deal with that a little bit. Our series is, after all, called Court as Conscience Keeper. And Prashant, I'd like to take this a little bit further with you. As if we've all argued for a while that the court is a political actor and must see itself as such. So while on one side, if it's going to say that we want a solution to the farmer protests that are currently going on, then of course it's going to get the Prashant Bhushan like criticism, that it's perhaps
Mhm.
aligning with somebody. If you're going to wade into a political dispute, that too politically,
Mhm.
and it's not a one-off. It's done it in Shaheen Bagh. It's done it
Yes.
in every single case of political moment. So
Yeah.
how do we think about the court performing this constitutional function, which still exists,
Mhm.
of being
Mhm.
some kind of conscience keeper by upholding the law,
Yeah.
while becoming almost willy-nilly a political actor? What's that balance? As in, is it looking like the American Supreme Court more and more, that you try and, in particular kinds of cases, as in you decide against the government, so you become a conscience keeper? Or is there some other kind of way where you think the Indian Supreme Court might continue to remain a conscience keeper while becoming more and more political?
Look, for me, I think there's two ways to answer that, or two strands in which one is that should it continue to be a conscience keeper or should it not? I think for me, the way that I want to sort of answer that question is to say that it depends on what it does with that. If it's going to continue to behave as a conscience keeper or think that it is a conscience keeper and then use that, ideology to try to come down on people and punish them for contempt of court. Okay, that is a bad way to be a conscience keeper. Now, just about that term itself, that's something, in analogous terms of that sort. I think the judiciary has been called not just, by a whole range of people, by academics, by filmmakers, by, newspapers, by journalists. The Supreme Court particularly has repeatedly been flattered in such terms as, conscience keeper, people's court, as the first among equals, the central pillar. It refers to itself in these terms. Now, the thing is that this is not, by the way, this is not necessarily the Supreme Court talking about itself. In fact, the framers of the Constitution itself, if you look at the Constituent Assembly debates and, the committee discussions, it conceived of the Supreme Court as a guardian of the Constitution. So I'm not, this is not a rhetoric that the Supreme Court invented. But the problem is that the Supreme Court has sort of gone overboard. It has taken this up way too seriously, and so now it has too lofty a notion of itself. And I feel like that is damaging, because the thing is that the idea of a guardian of the Constitution, I think that the Supreme Court had, was not as someone who, not an institution that would go chasing after people for their sort of perhaps intemperate comments about the Supreme Court. It had the framers had the notion of a guardian of the Supreme Court that would take possibly a counter majoritarian stance,
That's right.
against. So the thing is that I feel in that particular avatar, whether I think that I would say that look, the Supreme Court cannot escape being political. It has to be political. It is invited to be political. It is, in fact, in some senses, one could argue that it is constitutionally designed to be political. But the nature of that of its politics, a lot rides on that. If it is political in the sense of being constantly, collaborative with the, with the, with Parliament, with the executive, with the
That's right.
majoritarian regime, that is definitely something extremely, something that we need to be wary of.
Yeah, that's right.
I would
I
like to.
think I think that, sorry to just stop you there, because I think it's actually a good point to get Venkatesh in, because I'd like to take Prashant's point a little bit further. Is that the reason why the Supreme Court has this image that it is above politics and it's this conscience keeper, while of course not being an original idea, is because of a media narrative that has been created. Okay, it's a media narrative that has been created for a long period of time, that the Supreme Court is the conscience keeper. During the emergency, it had its lowest moment, and then it comes back up and rediscovers itself as being the guardian and the sentinel on the qui vive, and battling for the poor, batting for the poorest of the poor. As in, this is the dominant media narrative of the court. And given the fact that there is much more, and Venkatesh, you said that there is much more scrutiny of the court at this point of time, how do you see this changing, if at all? Or do you still think that the Supreme Court is in some way a conscience keeper to ensure a check and balance on an overweening executive?
That's an interesting question, Arghya, because uh, I must say that when we think about the Supreme Court, really, we as journalists, we regard it in two ways. The first way is we think of it as the guardian of institutions of democracy in India, not just the press, but other institutions as well. And as people in the media, we have close relations with the legal system, people in the legal system, and really, I would say in that perspective, if you look at that line of thought, we still think of the Supreme Court as something that is above it all and can, deliver justice, so to speak, in those terms. The second way of thinking about it, about the Supreme Court and various other courts, of course, is that it is staffed with people who are regular people and who are probably bowing to the political winds. When you look at it in that perspective, there is a certain level of caution that comes into play. And we in the media are much more careful these days about what we say. While at the same time, in social media, you will see us also criticizing judgments. At the same time, we are also sort of worried that are courts increasingly getting more and more politicized? So I would say for us, it's kind of bifurcated in two ways in the way we look at the Supreme Court specifically because of what we've seen in the last 2-3 decades, especially after emergency. And we've seen the Supreme Court kind of emerge from the emergency. So that memory is still very much with us. And of course, you did mention media narratives. And the media likes to have, it likes a story, likes a narrative, likes a hero, likes a villain, as you very well know. And those kind of narratives will continue. Every time we have an individual judge who makes a pronouncement, there will be a narrative. There'll be a hero versus villain narrative. It may not be very, very specific. It may not be in your face, but that narrative will be there. And each time the institution of the Supreme Court does something or is forced to do something, there'll be that narrative that emerges as well. And so I would say that, yeah, there's a third element. Of course, we are influenced by the court, but we also shape the perception of the court, not just for ourselves, but for the public as well. So there are many, many strands here. And each of these strands are, of course, quite fascinating to go down or paths to go down and explore further. But I think I'll leave it there for the
No,
moment.
but I think the point that you're making is a very interesting one, given the fact that every time the media makes a story about the Supreme Court, which is about heroes and villains, the good guys and the bad guys, then the court every time becomes a little bit more political. And by political, I mean a little bit more accessible that people can understand. And it's not sort of talking in Latin terms anymore, and discussions between lawyers, but people have a view on the court. Like, as it's just to give you a very recent example from about a year or two back, the court was hearing a case about banning diesel taxis in Delhi, and I was going to the court, and as it happened, I just asked the taxi driver whether it was what kind of taxi it was, and he said it's a diesel taxi. And I was going to the Supreme Court, and the Supreme Court had just banned diesel taxis a day or two before. And so I said, don't you feel a little afraid that you're going to the Supreme Court in a diesel taxi, that it is banned? And he says, you know what, the court, it'll say something today, it'll say something else tomorrow. So I thought that was interesting. That here was a person who was trying to engage with it, and the engagement was that it's just like another political institution, that they say one thing today, and he could have just said politician, but instead of saying politician, he said the court. So it was quite interesting that people are beginning to engage more and more with the court. And I think what we are perhaps reaching, Prashant, seems to be some kind of inflection point. I wouldn't call it a point, but perhaps a range where the court, as one, has to shed this idea of being above it all, but continues to persist with it because of the first strand of what Venkatesh said, that there is still that history that is very much alive. But at the same time, as it has to essentially, in the words of Justice Roberts, as call balls and strikes, as in it has to adjudicate the law as it sees it. So how do you see the court having performed this role vis-a-vis free speech related issues in the last 4 or 5 years? Prashant?
Um, I think, Argo, I think you said it absolutely right at the beginning. You said that the court has a patchy record. You were talking about examples from the past few years, but I think throughout its history, it's had a fairly patchy record. Actually, you know what? I want to kind of go further and say that perhaps it have had a more positive than a sort of a negative record in upholding freedom of speech and liberty, at least in terms of its normative articulation. I want to kind of, if you step back and say that, the context in which the Supreme Court of India pronounces on Article 9, on freedom of speech has been Article 19. And I mean, I don't know how familiar your viewers, your listeners are going to be with Article 19, but it's the article
Reasonably.
of the
Let's
Indian
assume a
Constitution,
reasonable for
yeah, which talks about freedom of speech and expression. Now, Article 19 is actually a very curious article if you look at it in terms of its drafting, because I think if you look at the way that it was drafted, one witnesses in Article 19 a very reactionary element in the draftsman. That is, if you think, the draftsman is article, the people, the founding the fathers of our constitution are doing something extremely surprising with Article 19. Because if in one sense, if you look at the way that our independence struggle proceeded, it is, you can view it almost as a history of seditious speeches, of speeches against the government, of against the colonial government, and of speeches that are extremely censored. So one would think that people who had had that experience of censorship would put in a much more stronger provision of, in Article 19. But if you actually look at the Constitutional Assembly debates and the committee reports on the fundamental rights, in fact, what you'll find is quite the opposite. You'll find that there's a very cursory discussion on the importance of free speech itself. But the bulk of the discussion is on how many ways to encumber that freedom. Now, the thing is that, so this, for me, it marks a moment. So, I mean, if we are disappointed at the Supreme Court, one should actually go one step further back and be disappointed at the draftsman for the fact that they did not, having, let me use this metaphor. They used a ladder to climb up to independence, and then they immediately threw away the ladder. So the particular so they didn't give us a robust enough freedom of speech and expression, which the Supreme Court could then sort of carry forward and expand.
That's right. So I think that's precisely right. And I think we don't have we don't interrogate the Constitution as much as we should. And I think we tend to look at it in sort of very celebratory terms. And there is a lot to celebrate in the Constitution. There's no doubt about that. But certainly, as far as the fundamental rights chapter is concerned, as in we see a very conservative document. Okay, and we not only have various restrictions on free speech, we have preventive detention, which is provided for in the Constitution, in the fundamental rights chapter, and a number of other restrictions. In fact, every right is restricted pretty severely.
Absolutely.
And if we come to the restrictions on free speech, and Venkatesh, I'd like to bring you in here, as if the restrictions are not just contempt of court. The restrictions relate to law and order, security of the state, sovereignty and integrity, decency and morality. So there is and of course, defamation. There's a range of restrictions that exist within the constitutional text, which the court is duty bound to uphold. Yeah. Now, how do you see this as a journalist, that there are so many restrictions on the freedom of speech, and sort of one thing to what Prashant said, as there were a few restrictions to begin with, and the same Constituent Assembly sitting as the first parliament expanded that scope with the first amendment to the Constitution. Yes. So how do you see that?
Yeah, I mean, let me answer it in two ways. Let me come to your question in a moment. But what you were asking me and what Prashant was saying made me remember something I'd read, that the First Amendment of India and the First Amendment of the United States, there's that contrast, right? The First Amendment upholds the right to free speech without any reservations in the United States. I believe it was the 1951 amendment in India, which was the first amendment, which brought in those restrictions on freedom of speech, free speech.
Some of them.
You look at these two, and then you add a third. You look at the Philippines, which I was speaking to the celebrated journalist Maria Ressa, and and I asked her I told her, look, you're American, Filipino American. Do you see a difference in, does a law need to be changed? Does it need to be changed in the Philippines? And she said, look, essentially both the Philippines and the United States, they both guarantee free speech, but look at the state of free speech in our respective countries. I mean, how different is that? So when I think of it, whenever I think of what the Constitution has to say and what successive amendments have done to the right to free speech and the right to freedom of expression for journalists, I always think about this. This is my personal perspective. You'll have all these laws, but isn't it culture and isn't it society that kind of shapes whether you're going to be able to uphold the law or uphold the Constitution or not? So that was my limited point. Now, to the question that you asked, how do we see, or how do I see, the number of challenges on upholding the freedom of the press are immense, and there are so many structural and non-structural challenges, or should I put it this way, tangible and intangible challenges. So you have the variety of laws, whether it is pre 1947 laws, British era laws, whether it's laws or amendments that were, either through legislation or through precedent by court. That is the second type. And then there is, you have the kind of restriction in states of India as well, depending on where you practice your journalism. And in fact, I do remember one essay I read called The 8 Threats to Freedom of Speech in India. And that was by Ramchandra Guha. And he says, of course, that it's not just these, but you also have other things. You have identity politics, you have, the social media platforms that kind of privilege, even sometimes without meaning to do so, certain types of speech over other types of speech. So in every direction, I get the feeling as a journalist that my freedom to say what I think is honest and is getting sort of hemmed in. And as a journalist, I'm very, very aware that there is censorship, not just through the courts or not just through the government, but also censorship by mob, and which leads to self-censorship. So very broadly, to answer what you said, yes, I do believe that there are lots of threats to the freedom of expression in India, which is very, very closely tied to the freedom of the press.
So I think let's take yeah, Prashant, come in, please.
Can I just
yeah, sure, go on.
So all I wanted to say was that just to complete the thought that I had begun with, which is that I think that we started off with an extremely attenuated freedom of speech clause in our constitution. But given that framework, I feel the Supreme Court has done fairly well to try to expand that and to sort of include within the right to freedom of speech and expression, the right to receive freedom of speech and expression. And it's constantly sort of trying to push those boundaries. We saw that with the Shreya Singhal case, but we saw that with a few other cases before. The older cases that had to do with the right to appear on Doordarshan and stuff of that sort. So the thing is that we don't have a very good sort of statutory provision, constitutional provision to work with, but and so the legal nature of our right of freedom of speech and expression is exactly as moth-eaten as the Constitution allows it to be.
That's right. No, I think that's a very good way to put it. And that's perhaps a segue to start looking at this question of free speech, not as a purely legal question, but as Venkatesh said, as a political and a cultural question. So I think there's 2 points coming out of that first segment, which is the fact that we perhaps inherited a colonial state and we did very little to change it, and became in some sense more colonial than our colonial masters, particularly when it came to free speech. And number two, that what we see now is that these threats have expanded, and apart from a colonial state or a colonial like state and 28 states that we also have now a fairly colonizing private sphere. And when we talk about these the larger societal constructions which allow a country to be free or not in its speech, then we have to think about private actors. And because private actors, apart from the state itself, are becoming more and more relevant in terms of deciding what we see, what we read, and for a long time, this has got a lot to do with media ownership and who owns our media. But now, as in the digital media too, which was seen as the Wild West, where anybody could say anything, we see that there is of course, in some sense, the private, I mean, the social media sphere is sort of a slave to some kinds of manipulative consumption. So, Venkatesh, given the fact that a lot of your work is essentially in digital media, and digital media is now running on the basis of fairly opaque algorithms. And when I say digital media here, I particularly have in mind gatekeepers of the nature of large social media companies, which tend to determine what gets seen or not seen. Uh, how do you see large private actors and their interface with free speech?
Well, if you're speaking about the social media companies and technology companies, if you're referring to them as a particular kind of private actor, kinds of private actors, yes, I certainly see that we've noted in the last few years that these social media companies and technology companies have increasingly, as you mentioned, become gatekeepers. Before we were the gatekeepers, so there was a little bit of adjustment there. We felt that we were the guardians of what could be said and what should not be said, and then that was taken over by the social media platforms. But even if you leave that aside, this complete disruption in the media industry and journalism space, where we've had to kind of rethink our relationship with our readers and rethink what our profession means. Even if you keep that into consideration, I do believe that social media companies have a huge responsibility in this area, and that there are all kinds of ways of restricting freedom of speech using algorithms. There is algorithm bias, as you know. So it doesn't necessarily have to be a state actor. It can be a platform just deciding that certain types of content based on certain keywords will not be distributed to the intended audience based on the algorithm. And it's when I say algorithm, I don't just talk about the Facebook feed or the Twitter feed. I'm also talking about email. Let's say I start a campaign to uplift whatever, whether based on caste or gender or sexuality or whatever it is, uplift a certain downtrodden member of a downtrodden community in India. And let's say I start a newsletter. Now I depend on the algorithm as to whether that newsletter is going to go to the promotions tab or whether it's going to go to the primary tab. So wherever journalism kind of emerges, it runs into a wall, and that wall is technology companies, algorithms. So you have algorithms, and then you also have humans who have designed these algorithms, and then you have biases that come into play over and above that. So certain types of conversations and certain types of journalism are privileged by the design of those of the algorithms over others. And that's just one part when you speak about social media. There are other aspects to social media as well. And of course, these are not the only private actors. There are several other private actors. And
That's right.
we can talk about just one point. We can talk about how social media companies, how they interact with media companies, how they interact with the politics of the day. And so it's like this triangle. One can amplify the other, one can sort of push down the other. And in conjunction, when you look at it, the whole space for expression and the whole space for journalism is curtailed.
That's right. So what I'm taking away from this is that there is immense power that technology companies have, and immense power, as you rightly said, comes with some degree of responsibility. And so, Prashant, as in, if you were to don your legal academic hat, as in, how do you conceptualize this responsibility? And this is especially given the fact that Part 3 of the Constitution applies strictly against the state, because we thought that the state would be the biggest threat to free speech. It strictly speaking doesn't apply against private parties, though we know all kinds of ways in which horizontal obligations can be brought in. But given the fact that they have state-like power, how would you conceptualize the responsibility of large technology companies?
Yeah, in some senses, what we're going through is both very new but also very ancient. If you look at the foundations of the public sphere, and I'm sort of referring to a scholar called Habermas. Many of you might be familiar with. He's written the canonical work on the structural transformation of the public sphere. He charts the rise of the public sphere, which begins in coffee shops across Europe from the 16th century onwards. then transforms into what he calls the bourgeois public sphere, and then which is which consists of a bunch of newspapers and journals and commentary of that sort, and then transitions in the 20th century to a mass public sphere, which is completely sort of commoditized. Now, the important thing, the key element in this is that the public sphere has always been, in some senses, built atop private capital. Whether it's the small coffee houses or the small newspapers and newsletters, or the network of newspapers and newsletters, or in the 20th century, the broadcast houses, the radio networks, and what have you. Private capital has always had a governing influence on the shape of the public sphere. Now, in that sense, what's going on with Twitter and Facebook is not very substantially different. It's just that, earlier, in every phase of its expansion, whether in the print phase or the radio wave phase or the internet phase, there's been a period in which this new sort of technology has thought to be ungovernable. Like when the first radio wave became a thing, it became, pretty much the same anxieties that we now have about the internet existed back then. It was thought that this was a completely ungovernable media. It could completely transcend boundaries. People could say anything. But as we know, what happened very swiftly is that the different nations of the world carved up their airspace and the radio wave space, and radio is now as heavily regulated as any other media. Now, something similar might also happen with the internet. I think it's still too early to say, or maybe I'm also probably a little behind. Maybe it's already happened to a great degree, but certainly we don't have that much freedom, or at least we perceive this. We don't have as much freedom today as we probably had 20 years ago with the internet. The internet, I'd say, was far less regulated 20 years ago than it is today. Now, within that context, the particular question that you asked me is that, do companies like Twitter, Facebook, WhatsApp, social media companies, Instagram, what we're seeing is the internet sort of being consolidated into 3 or 4 very large social media companies, which exercise an outsized influence on what we receive and what we can say and who we can say it to. Now, what sort of responsibilities can we attach to them? And now this is where, I feel, one could either be very pessimistic or very, very optimistic about it. One could be very pessimistic about it and say that, look, and take the example of what happened with Facebook recently in India. It was, exposed as having extremely close links with the BJP and having, essentially, participated in the purveying of fake news to a very high. To what extent we don't exactly know. Now that obviously is a extremely bad example of how things could be. But on the other hand, I feel like what's happening in the US right now is something that's very, very interesting, because one is witness to to a very strange phenomenon of the president of the US. His tweets. I don't know if you've seen this, but most recently during the elections, a lot of his tweets had a qualifier at the bottom saying that this was fake news. Now the thing is that if such a thing can be done by a private company, without any regulation, this is essentially taking on arguably the most powerful man in the world. Could something similar be brought into India? Could something, could etiquette of that kind take care of our concerns of power that we have?
Yeah, Venkatesh, come in there.
No, I was just responding to what Prashant was saying, responding to 2 points that you made, Prashant, which is, the thing in the United States was the technology companies started labeling his tweets after the election, when the counting process was well underway. So but at the same time, I do agree, even before the election, Facebook and I'm not sure if this includes YouTube as well, but certainly Facebook took in certain measures to make sure that some types of political advertisements are not widely distributed, and it's a huge precedent for the rest of the world. In fact, I've been arguing that it puts pressure on these tech companies to do the same in other countries as well. Even though it's these kind of safeguards have been removed just in the last 2 or 3 days, I believe, where you now you can retweet whatever you want to, like you couldn't in the last month or so after the election or just during the election. So that's one. The second, of course, is I did take your point about how the public sphere sits on top of private capital, but my question is, before it used to be radio, television, newspapers. It was the mass media model. Now it's the mob model, right? Everyone has a loudspeaker, and not just everyone has a loudspeaker. The Everybody can be weaponized. I mean, a single entity can weaponize masses of people against another mass of people. So I'm wondering whether we should conceptually think of the question, the threat in a fundamentally different way, because I may be saying something else that does not make sense, but I do believe that when you look at it conceptually, maybe there are other ways of addressing, building the framework to view the challenge.
Absolutely.
Thank you.
Go on.
Thank you so much for that. I feel that in some senses you've completed my thought, because I started out by saying that what we're experiencing is both very new but very old. But I think I ended up fleshing out the similarities with what went before, and not marking out enough how different the situation that we are in is historically. And I think you have done that in the sense that yes, we do need to kind of think of different ways of bringing in accountability. You are right in the sense that the mass media model was somewhat relatively easier to bring under control and to tame than the internet. But the pushback would be that for all of the internet's wanted openness, what the phenomenon that we are seeing right now is a sort of consolidation of the internet into 3 or 4 big media giants.
That's right.
Okay, and this is not this is literally, I mean, one could say free market forces has brought about the massification, essentially the concentration of this dispersed media into 4 or 5 houses. Now that provides a site where regulation can intervene.
That's
and
right.
Now the quality of that regulation is something that I don't know. But I'm saying that the same sort of anxieties. If you look at the archives of how radio waves, when they first erupted, and the regulator's anxiety about how it was getting out of control and the kinds of things that people were saying, I think we inhabit similar senses of anxiety, which is on one hand, we're extremely entertained and informed all the time. On the other hand, there's this extremely pernicious side of the internet, which facilitates mobocracy, facilitates the advance of fascism. Let's not use that word, but majoritarianism.
That's right.
To a far greater degree than was possible before, or I don't know, far greater degree maybe, but to an impressively high degree.
Yeah, that's right. But as a friend of mine has just messaged me saying that I'd rather take the mob-like atmosphere of the internet than a few television companies who are opaque in their ownership structures. So I think there's two sides to everything, as in that, and certainly with the technology companies doing what they have been doing regarding President Trump's tweets, I think there is a real discussion to be had there, because as President Trump himself was saying that when he wanted to amend Section 230 of the Communications Decency Act, that if you say you're an intermediary, then behave like an intermediary, which is just make sure the messages get sent from A to B. And if you are going to play this kind of mediating role, then in that case, you're more and more like a publisher, because you're taking certain calls on what needs to go out with what kinds of labels. I think we can go on for a very long time, but we've got a set of questions, and I think there are some interesting ones. So we are open for questions. We've already got a few. So if you have any questions, please do type it in the chat box. So I'm going to take one first from Anand Sangal, who says that isn't the fact that the Supreme Court has been imbued with the power, I think we've lost Venkate. No, we've lost Prashant. So maybe we'll just wait for him to get back. So there's
Sorry, I was just looking at the chat screen.
Okay, no problem. So I'll read out the questions that we can take. Yeah. So isn't the fact that the Supreme Court has been imbued with the power to issue contempt by the text of the Constitution itself laid the foundation that the court must take itself very seriously. So this is going back to the text of the constitution
Yeah.
question. Otherwise, what else could be the justification for providing for contempt in the constitution itself? Prashant, you want to take that?
Yeah, that's absolutely right. Which is that if the Supreme Court believes that it can punish people for contempt, it is because it is a right that has been gifted by the text of the Constitution itself. But actually, let's go further than that. If you read the Supreme Court's recent judgment in Prashant Bhushan's case, it in fact describes its power. It notes that the Constitution says this, that gives it the power, but it in fact goes further and says that, look, it has the inherent power of punishing for contempt. That is, regardless of whether the Constitution put down those words contempt of court at all, the Supreme Court's own conception of its power is that it had it anyway, and it had it anyway by virtue of what it is. Now, the thing is that there's two aspects to that. I feel like, the Supreme Court, one must remember, is possibly the most medieval of India's modern institutions. Parliament, executive, these are recent phenomena, but the court, in fact, the judiciary goes back a long way. And the thing is that this contempt power comes from medieval times. It is a medieval power. There's nothing to be proud of about the fact that the Supreme Court refuses to shed a medieval power that it had. So, in other words, what I'm saying is that I feel like what would be very appropriate for our times and appropriate for the Supreme Court is if it would consider using its great inherent powers under the Constitution to abolish this power of punishing for its contempt. Look, if you look comparatively, almost all common law jurisdictions have inherited a notion of contempt of court. But what they've done is that they've restricted it to situations where people, appear before a court and behave inappropriately. Someone standing before a judge and shouting it at them. But most jurisdictions, the kind of contempt that the Supreme Court currently is punishing people for, most jurisdictions, most sort of common law jurisdictions have sort of done away with that, either in practice or formally by law. So you don't see, similarly people being hauled up for scandalizing the power, the court in the US or UK or Australia or Canada, right?
Yeah,
sorry,
so
I don't know.
I think that hits the nail on the head, and I think that is obviously an overt restriction on free speech itself because of historical factors. There's a question come comment from someone who's anonymous, which I think is interesting, which is broadly to do with self-censorship, and they are asking that given the fact that we are living in a changed scenario, that freedom of expression today, as it should be seen not only in individual terms, in terms of what it does to an individual, but also in community and society terms, that what it says about our liberal democracy. And the second part is that perhaps related to that is this issue of self-censorship, that given this sort of atmosphere that is not directed at any one person in particular, but this atmosphere that is being that has been created, which not necessarily in the recent past but for a while, that stultifies free speech. How, Venkatesh, do you see this self-censorship in this current atmosphere?
Self-censorship is a real problem, is a huge problem. And it affects everybody. It affects journalists. It affects non-journalists, individuals as well. I think, for me personally speaking, fear is a huge factor. So I've got to think about various fears when I speak out. And I've arrived at a kind of personal way of dealing with it, which is I will say whatever I think I should say in consonance with my values. And I will hope that my journalistic brethren will back me up. So even when you have this impulse to self-censor, if you've got if you got the support of people around you, it is not so much of an issue. Which is why you will see that even though you will have less restrictions on digital journalism, you will find print journalists far more able, for example, to take more courageous positions sometimes, and the reason for that is they've got the support or the backbone or the system of the newspaper. You've got 300 journalists, whereas a digital journalist might be working in a newsroom with 20 or 30 journalists at the most. So I will say that this self-censorship thing works in really weird ways, and it comes together when with mob censorship, which is really using culture, society, and social media to drive home a particular point and to kind of tell you or dictate what kinds of topics can be discussed safely and what can't be discussed safely. And it is going to be a major problem going forward as well, self-censorship. But there's that other saying, right? It's much abused saying, we were asked to bend, but we crawled. So when you look at it that way, self-censorship, sometimes fear works in weird ways as well, in that it makes you be far more circumspect than you really ought to. So I believe that for a journalist, self-censorship is a concern, but you will see that not too many journalists really censor themselves,
That's
especially
right. That's encouraging to know. That's
yeah.
encouraging to know. Because sometimes it seems like censorship works in more potent ways than any overt form of
Oh
censorship.
yeah, it's very insidious. Yes.
Yeah, that's right. And it's very hard to identify when it has happened, and almost impossible to identify when it has happened. Another question is on this issue of national security, something that we haven't touched upon directly. So, Prashant, maybe I'll take that to you from RA, who asks that how do you see the increasing response of national security to questions of curbing free speech by the government in general? And of course, there are many examples that we see from cartoons in Mamata Banerjee in West Bengal to fairly innocuous tweets, as in by Kafil Khan and several others, all of which as in come under some rubric of national security or law and order. And there is criminal punishment and denial of bail and so on, and the entire criminal justice mechanism. How do you see this interface playing out?
I have two comments on that. Firstly, the national security concern of free speech is almost the primordial concern of our constitution with regard to free speech. That is the original Article 19, restrictions. It says that we all have the right of freedom of speech and expression, subject to defamation, and the other big category was national security. That's because the thing is that for at least from the 1920s to the 1950s, the colonial state was preoccupied by the overthrow of the colonial state by communist forces. So the thing is that the security if you look at all of their concerns about free speech and propaganda, they have to do with how do we defeat the communist threat. Now the thing is that sort of spilled over into the our post-Indian independence state. The problem with the drafters was, possibly, and I may quote controversy by saying this, is that perhaps they were too good lawyers. They were too well schooled in the law to discard this. So they threw in security of state, and as a result of which, to this day, governments have the power to summarily suspend our freedom of speech on the grounds of interference with the security of the state or the defense of the nation. What is different is this, that in the last 50, 70 years, the executive in India, by which I mean the police forces, have become far more sophisticated in their repressive abilities. What I mean by this is that, if you take the example of, the most recent and the most painful sort of episode in our history, is the Elgar Parishad case, where, 5 extremely noted human rights activists have been, imprisoned for the last 2 years on fairly trumped up charges. The thing is that what I want to highlight about that case is this, that here you have a police force which is extremely adept at coming up with absolutely, rubbish, allegations, evidence, things that look like evidence, and foisting it on you, so that, your freedom of speech and expression is impaired. Not because you tried to actually overthrow the state, but because this is available as a ground, and so they will manufacture evidence about you that looks like you are about to overthrow the state. So that really is the concern. I mean, in the sense that not so much the existence itself of that term in the statute books, but the fact that, our executive has become extremely adept at using every word in our statute book and our constitution as a weapon against the citizens. So
Yeah.
that is something that is far more detrimental, and it's a formation that's much more threatening to our freedom of speech and expression than the technical language of our constitution itself.
Yeah, and I think that asks some fundamental questions about law itself, as in there would obviously be, as in a serious Marxist critique of the law, that it is essentially meant to do what you're saying, that it is essentially meant to be as a tool which is going to oppress. So I think this is a much deeper conversation which we'll have to leave there. But one last question from Aman Sinha, I think a very topical one, though constitutionally a bit distinct from free speech, but clearly interrelated. And he asks, what is the future of the right to protest and what is its scope vis-a-vis freedom of speech and expression? We'll have to end it with that. So, Venkatesh, a last word on where you see the right to protest. Do we see this in terms of rights? And how do you see that in relation to free speech and expression? And then I'll come to you, Prashant. Venkatesh.
I think the right to protest is increasingly getting curtailed, and I'm not very optimistic in that regard, because one thing I noticed when I was going past the White House in Washington D.C., I think it was in 2017, was there was somebody who was protesting right outside the White House. There's that space right outside the White House where you can protest. In India, in New Delhi, you cannot protest in front of North Block or South Block or Rashtrapati Bhavan. You can't protest on Rajpath. You can't protest in front of the India Gate. You're tucked away somewhere in the side near Jantar Mantar when you protest. So this, in a very geographical sense, the right to protest has not been there for a very, very long time in India. And now even public parks, we did see a lot of the anti-CAA protests last year. The spaces were there, but each time it was the sheer number of people that really forced the media to take notice and for people to realize that there were large numbers of people coming. But what happened to those protests? The pandemic came, and then now there are a lot of legal threats against people who are protesting. It's not actually, I'm not saying it's concrete, but it's implied. So it kind of takes away the kind of space you have to protest, in my opinion, especially in national level protests. Even though we are talking at a time when the farmers are picketing the Delhi capital, I do believe, that is a huge bright spot. But I'll have to see more personally to be convinced that the right to protest and the right to dissent is not being curtailed going forward.
Yeah, I think, as in, just to add 2 cents there, as in, it's obviously very selective, right? As in, it depends on the kind of issue. As in, if it is a core constituency that is protesting, then obviously it has better outcomes than perhaps a minority that matters very little. So I think it's sort of very much on a case by case basis as to whether the right is going to be curtailed or not. Having said that, we do live in a time of quite a bit of protest, though. Last word to you, Prashant, as in, given that the right to protest also produced this rather curious judgment from the Supreme Court in the Shaheen Bagh case, which was a little bit, I've written saying that this is some expression of judicial anguish that reads like a homily and should be best avoided, especially given the fact that the court says that there is no right to protest in a public place. And then today, obviously, the farmers are picketing all of Delhi's borders, as they should and as they have a right to. But clearly, there's some Supreme Court judgment last year which said exactly the opposite. So how do you see the right to protest and the Supreme Court? Last word to you, and then we've got to stop.
Okay, I'm going to try to be quick. Look, the right to protest has, I share that concern and that anxiety about what's happening to our right to protest. But, if you look, give it a 150-year perspective, the right to protest, especially for the marginalized in India, has always been exactly as fraught and as perilous. You could lose your life in a police shooting. This is not just today, tomorrow, this government. It is a continuous history of protesting, being beaten back, being lathi charged, and being, particularly, if you are an Adivasi or a Dalit or any sort of minority, you have absolutely no such safeguard. This was true in colonial times. This continued in post-colonial times. Today, the difference is, I feel like, there's a much more greater willingness. Earlier, sort of the middle class and the upper middle class protests, were relatively sort of left uncriminalized. But today there seems to be, if you take the example of those two girls, those Pinjra-toed activists who've been in jail, over the CA protests, what's happening is increasingly that the government governments all over India, but especially the ones in the center, are ready to sort of incarcerate people from the middle class and upper middle class, and that is something that is obviously concerning in the sense that if even the middle class and the upper middle class won't be spared, then who is this government going to be accountable to? So all this to say that yes, these are difficult times for the right to protest, because you're living with you have a government which is not impervious to being shamed, let's say.
Yep.
May,
Yeah, I
may
think.
may
Yeah,
I add
quick.
the coda? I mean,
Yeah.
Prashant, what you said was very interesting for me, because yes, you're right. It's the rights of the upper middle classes and the so-called elite, or the elite, whose rights have been curtailed to protest. And perhaps we've been feeling the pinch a little more. And yes, the dispossessed in India have always had a tough time. And I actually see bright spots there. I see increasing spaces for Dalits and Adivasis and all kinds of minorities to express themselves increasingly. So we can't make a blanket statement, which is precisely what I did a few minutes back, and I'm amending that right now.
So that's a great coda to end with, because this is just the changing nature of our politics. And I think that perhaps, and this is a bright spot for change, that if people who are, as in traditionally been power wielders in India, are also subjected to equal treatment of the law, no matter how insidious the law is, perhaps change is afoot. I have to stop it there, but it's been a really thought-provoking conversation. Thank you very much,
Yeah.
Prashant and Venkatesh, for
Thank
joining
you
us,
so
and for
much.
all the attendees joining us on a Saturday evening for this discussion. I think what we're taking away is that we live in difficult times for free speech, but all time periods in most centuries have been difficult times for free speech. So perhaps it's not as exceptional. So there is no reason to be excessively pessimistic. Thank you, Prashant. Thank you, Venkatesh, for
Thank
joining
you.
me
Thank you
today.
so
And
much.
thank you again to all the participants. Have a wonderful evening. Good night.
Thank you, everyone. Yeah. Bye.